Hi everyone, welcome to Communication and Conflict, promoting mindful communication and growth through conflict. And this is also a podcast under the name Chaos, CAOS, which can be found on Anchor.fm and on Apple Podcasts and various other platforms as well. So today I want to talk about why most bullying and harassment policies are ineffective and what can be done to make them more effective. As you may have seen from some of my other videos, the area that I work in, or one of the areas I work in, is workplace disputes. I've been a mediator for 25 years, and I've often been called into workplace disputes to deal with situations which will almost always have included within them an allegation of bullying. And I've talked elsewhere about why mediation is a much more effective way of responding to allegations of bullying, so long as it's clear that there isn't harassment within the situation, because harassment is an illegal activity, bullying is not, and that distinction in itself is often very significant with regard to how organisations are effectively or ineffectively responding to difficult situations at work. And in turn, often that's informed by the policies which underpin how staff, HR staff, maybe senior managers or managers, respond to difficult behaviours at work. The policies themselves can often really be an indicator as to whether any such situations are going to be dealt with effectively or not. And I have to say, in almost all situations of bullying and harassment policies, I would say, looking at them, it's very clear as to why they don't get dealt with effectively, and why dealing with such situations becomes so long and stressful, and arduous and incredibly expensive, and doesn't manage to retain staff, and it affects team morale, and you name any kind of damage that it could cause. It pretty much leads to that being the outcome, because there's such ambiguity about the policies. So today what I want to do is talk about the general nature of bullying and harassment policies, and why the kind of general template for them is so ineffective as a starting point, but to look at what can be done to change them such that they are more realistic for the people who might have to use them, but also more promoting of the possibility of there being actually a re-establishment of working relationships which are broken, rather than what seems to underpin almost all bullying and harassment policies, that there will be a severing of any kind of relationship between the people involved, with no suggestion of anything ever being improved. But also kind of the kind of lack of clarity about exactly where such allegations do go when they're made. But I'm also obviously going to be referring to what I've said in other videos about the important distinction between bullying and harassment. Bullying not being legally defined, and therefore much more ambiguous, and therefore needing to be responded to differently to harassment, which is legally defined and therefore needing to be responded to in a particular way. And again, I've said in other videos, for me, ideally, there would be a separate policy for harassment and a separate policy for bullying, so that there isn't this continuous confusion between the two, which means that it's never really clear what is being dealt with and how it's being dealt with. But because they're so different, and because one is legally defined and the other one is not, it makes so much more sense to have two separate policies for them. So that's the first kind of recommendation I would make before I even start going into detail about the kinds of things which I see as being difficulties, and kind of things that foretell that there will be a very messy outcome to any kind of allegations of bullying, particularly at work. So, after this, into examples and discussions of policies. So I'm going to go through what I see as the six main flaws in most bullying and harassment policies. So of general kind of templates of bullying and harassment policies. These are the kind of six main things that I see as being a problem. So what I'll do is I'll go through them and then I'll come back to each one later to outline both why I see it as obstructive to effective responses to bullying and harassment claims, but also what can be done to change that aspect of policies and such that it improves things. It prevents there being false expectations on of the organisation to be able to do things which it can't actually do. It also clarifies what it should be doing, but also it outlines what the reasonable expectations can be of the people making the claims, because so often policies don't actually identify what the people involved can do themselves, and often that's because there's an expectation that they kind of just sit passively by while the whole process goes ahead, and that's a very ineffective way of responding to things, because the more the people can be involved in improving the situation themselves, the more likely there is to be an effective outcome. So the first one is, and I've mentioned this before, the fact that most policies conflate bullying and harassment as if they're pretty much the same. I'll give you an example later where one policy almost sounds the same for both bullying and harassment. It doesn't even make a clear distinction between the two in many ways of looking at it. So they don't clarify that harassment is legally defined, and even where that is referred to, sometimes it doesn't actually give the definition, which would be very useful within a policy, because then everybody can see what the basis is on which there will be an assessment of whether harassment is considered to have occurred or not. But it also doesn't make clear the distinction that bullying isn't legally defined, and so sometimes people start a claim thinking that it might end up going to an employment tribunal, but a bullying allegation will never go to an employment tribunal because it's not a legal term. It's not legally defined, so an employment tribunal cannot hear an allegation of bullying. So I'll say more about that later. But it just means people don't have that false expectation that it will go to an employment tribunal about bullying, but it can about harassment. A lot of policies don't make clear the legal duty of the organisation to deal with harassment. I've seen some policies that kind of almost suggest that the person who's experienced harassment, which is a form of discrimination, might be expected to try to kind of fix it with the person involved. And while they may choose to themselves, there should be no expectation that they should, because they've experienced an illegal act, i.e. harassment, which is a discriminatory thing. However, conversely with that, because bullying isn't illegal, not because it's not a bad thing to happen, but it's not legally defined, so therefore there won't ever be any legal case about it. It's actually entirely reasonable and possible for people to be supported in re-establishing their broken relationship if it isn't involving harassment or violence, for example, but is something which is what could elsewhere be characterized as bullying, because bullying is subjective, and so it's reasonable to expect that the people involved might try to resolve their difficulty or even take unilateral actions to improve their situation. So one thing that's particularly absent from most bullying and harassment policies is any mention of processes like mediation and conflict coaching, which can support a re-establishment, a restoration of that damaged working relationship. Now, a lot of people object to that, but at the end of the day, if they're not got a basis on which to take any kind of legal action, it's entirely reasonable that there can be support for them to do so, even though it can be understood that they may feel that will be a difficult challenge for them. And then And so, in effect, those are the three things: that there's no clear expectation that there might be an attempt to re-establish the working relationship within most policies. So it's almost written as if it just assumes that the relationship will only be broken once the allegation is made, that there's no possibility of the relationship being re-established. Secondly, it doesn't make any mention of supportive processes like mediation and conflict coaching as being available throughout the life of any dispute to support there being a re-establishment of the working relationship. And then the last thing being that there's no stated expectation that that might be something that people would be invited to take part in. So you'll notice I'm being very careful about saying they will be required to. You can't require people to participate in voluntary processes like mediation and conflict coaching, but it will be for them to decide, given that they're not going to have any legal case if it's bullying, because bullying is not covered by any kind of legal definition. So those are the 6 things. I've put them up on the screen. What I'm going to do now is go back through them in more detail for each one, and what the ways can be in which policies can be more supportive, more explicit, and therefore more realistic for people, both in terms of what they can expect from their organisation that they work for, but also what the organisation can expect of them in turn. So it's a more equitable situation as well, which is important, because otherwise people just feel they're just sitting there passively waiting for somebody else to come to a decision about what's going on in their working situation. So after this, we'll go into reviewing those 6 flaws and what can be done to improve them. So the first one, the policy conflates bullying and harassment. So you may have seen I've done another video on this, referring to the ACAS guide to bullying and harassment, which also doesn't do a very good job of separating out the two. It does acknowledge that one is there's a legal definition for harassment and there's not for bullying, but it doesn't really go on to highlight why that means there needs to be very different approaches, and the confusions and difficulties that arise when there isn't a different approach taken to the two. But that's a very common example of difficult policies on bullying and harassment. And as I say, ultimately, I believe there should actually be 2 separate policies so that there isn't this kind of confusion that goes on, and the ultimate frustration that it leads to all involved, when people think that because they've made an allegation of bullying, it's going to be dealt with as kind of clearly and easily as an allegation of harassment. I don't mean by that harassment in itself is an easy thing to deal with, but there's a lot more clarity about how you would assess whether there has or has not been harassment, and it will be a much quicker decision. But with bullying, because there's no legal definition, doesn't kind of really matter how long you take trying to decide, there never will be a conclusion which can be objectively asserted, because there's no legal definition by which to do so. And that's a very common difficulty, and it's therefore a very common stumbling block right from the start for any policy that if it does have to kind of talk about bullying and harassment in the same policy, it doesn't make a very clear distinction between the two. And I'll put up an example of this just to show you the kind of thing I mean. This is perhaps one of the more extreme examples of where there's very little clear difference, clear kind of daylight between the two. But it is an example of the kind of thing that can that is actually put out by quite large organisations in a lot of cases. So I'll just put this up on the screen. So I put it up on screen, and I'm going to read it out, particularly for people who are listening on the podcast. But what I'm going to ask you to do is, after I've read both definitions of harassment and bullying in this particular bullying and harassment policy, is just to think whether it's clear to you what the difference is between the two. I mean, one is longer, but whether you could actually genuinely say, on the basis of these two definitions, how you could clearly know the difference between harassment and bullying. So, what is harassment? We consider harassment to be a form of physical, verbal, or non-verbal conduct, speech, or behavior which makes someone feel distressed, humiliated, or threatened, and that has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. It could take place in any setting and be conducted through any form, including electronic communication. A single incident can amount to harassment. So, what is bullying? We consider bullying to be offensive, intimidating, malicious, or insulting conduct, speech, or behavior which makes someone feel vulnerable, upset, or threatened. It could take place in any setting and be conducted through any form, including electronic communications. Now, I just want to ask whether anybody reading it on screen or hearing me just read that out could actually genuinely say what the difference is between harassment and bullying. Certainly, other than the first one being longer and there being more written, in essence, what it's actually referring to, I don't really see as being any different. But actually, harassment is significantly different. It is clearly defined under law. Bullying is not defined under law, and harassment has to have reference to specific protected characteristics, and there's no mention of that whatsoever in this particular definition of harassment. Now, I'm not going to name the organisation that has this policy, but it's a large, I think, international media, printed media and digital media company. So it kind of staggers me that their policy on bullying and harassment makes no reference to the fact that harassment relates to protected characteristics and is legally defined, and and as is common, bullying is not legally defined. But there's no distinction made that would identify that harassment relates to protected characteristics. So this is what I mean. The two kind of sound like they're the same, and yet they're significantly different. So that's a major problem with most bullying and harassment policies. And just to add before I go on to number two, just to be clear what the definition of harassment is as defined in the Equality Act. And it sort of surprises me there's no why most policies don't even quote the harassment definition in their policies, because it would make everything so much easier, but for some reason it's left out. But harassment as defined in the Equality Act 2010 is unwanted conduct related to a relevant protected characteristic which has the purpose or effect of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that individual. Now, some people may say, well, that kind of sounds like the other two things I read out, but the significant thing in the harassment definition is that it's conduct related to a relevant protected characteristic, and so therefore if it relates to things like people's race, their gender, their sexuality, their religion, it's discriminatory, so therefore it's illegal. That's the basis for harassment being clearly an illegal act, because it's a discriminatory act towards a particular person. It's not kind of, I suppose, you could just call kind of unpleasant behaviour or conduct towards someone. It's specific to a relevant protected characteristic, and that's what makes harassment clearly into the realms of legal definition. So that's why harassment is significantly different to other unwanted conducts or difficult behaviours that people might experience in the workplace. It's related to a relevant related to a relevant protected characteristic such as race, gender, etc. So just want to clarify that, because, and there's no reason why any bullying and harassment policy could not have that simple paragraph within it so that people can see what is actually being referred to. But for some reason they don't. It kind of bewilders me. But anyway, so on to number two. So, having made a clear distinction in a good policy, having made a clear distinction that bullying and harassment are different, and ideally clearly identifying that harassment is legally defined, bullying is not, and ideally, as I say, including that definition within the policy so that everybody's clear how such things will be assessed. Um, it needs to also make clear that should harassment occur, then the organisation has a legal duty to take action where such things have occurred. It's kind of a duty of care that if something illegal is happening within the workplace, then the organisation has a duty to act. So again, I've seen examples where it's been suggested that people might have to try to kind of address harassment with the people who are harassing them. Now, as I said, if you wouldn't try to address if someone assaulted you that they're assaulting you would expect there to be action taken against them. Um, as I say, I want to make a clear distinction, because with bullying, because it's not illegal, then it is reasonable to address that someone's behaviour you're finding to be unacceptable. Um, but where it's the law is being broken, then you've got every right to expect your organisation, your employer, to take action against the person who's acting in that way. And so long as there is sufficient proof and you're able to have witnesses or evidence, or either written or somebody observing that reference to a protected characteristic has occurred, then you've got every right to expect that they should take that forward on your behalf. Um, but a lot of policies don't make that clear either. They don't say, in examples of harassment, as an organisation, we will take action based on clear, when evidence is clear that this has occurred. I mean, they could say it in a way which says, it gives them the kind of the caveat that there's got to be evidence. It can't just be any old allegation without evidence. But where evidence is sufficient, that the organisation has a duty to act. But so often you don't see policies say that. Again, it's all wishy-washy, and there's nothing that the organisation's placing itself at risk over. It's more placing itself at risk if it doesn't make that kind of commitment, because it has a duty to do so anyway. So if it doesn't state it, even if it doesn't state it in its policy, if it doesn't take action when harassment is evidenced and can be proven to have occurred, it's failing in its duty anyway, whether its policy says it should be doing it or not. So there's nothing wrong with an organisation saying within it, where sufficient evidence is present, this organisation of harassment is present, this organisation will take the necessary actions, including any legal action as necessary in order to protect its employees. Why don't policies say that? As I say, they're not taking any risks. They're saying what they have to do anyway. So why don't they say that so it's clear? But they're saying it about harassment so that they're clear they're not saying it about bullying. Because they could also say about bullying, I mean, and this is, I won't say that now because that's coming into the future ones. But again, the policy doesn't make clear where these policies aren't working properly. It doesn't make clear the legal duty of the organisation to take action where there's evidence of harassment. And there's no reason why a policy can't do that. So, I'll move on to the next one. So the next one is number 3. That I've kind of covered a bit of this already. So the policy doesn't give the legal definition of harassment, but also does not identify the non-legal characterization of bullying, such that it can't be dealt with via an employment tribunal. So the first part of that I've covered. But in order to continue the clear distinction between bullying and harassment, it would be so much easier for policies and so much more practical for them to be and workable for them if they included the legal definition of harassment and identified that it's illegal, but also referred to the fact that bullying is not legally defined. So it's characterized, but it's not defined. So there can be someone's given their own kind of version of what bullying is, but in acknowledgement that it's not legally defined, that version is not taken as a kind of a legal basis for any action, but it might be a description of conduct that the organization considers to be inappropriate, but also acknowledging of the fact that well, two things. One is that it's still likely to be subjectively interpreted, which all bullying definitions are, and that's why they don't reach conclusions after investigations. But also because they're not legal definitions, that any expectation that people have that an allegation of bullying will go to an employment tribunal is nipped in the bud via the policy, rather than sometimes people kind of months down the line are still expecting that bullying allegations are going to go to employment tribunals because no one has either clarified that for them, or perhaps no one even themselves are aware that it won't. I mean, again, I can't quite understand that, because I mean, obviously legal teams will know that, or I would hope would know that. But perhaps when it before it's gone to the legal team, when it's still being dealt with by managers and HR teams, perhaps they're not aware that an allegation of bullying will not go to an employment tribunal. So again, this distinction needs to be made so that people don't have false expectations of what will happen as a result of making an allegation of bullying. As I say, if they have evidence for and want to make an allegation of harassment, and they've got evidence for it, they can expect absolute support from their organisation on a legal basis, that the organisation has a duty to take such things seriously and to take action. I'm not saying all organisations to do, but the employer has a much stronger expectation that the organisation will take action on their behalf, because it's an illegal act. But the expectation that the organisation will take action on their behalf on a bullying allegation is very different, because it will be, and as I say, a lot of people won't like me saying this, but it will be a he said, she said, difference of opinion, difference of viewpoint, and it won't be very likely at all. And again, the other videos that I've done will outline why. I mean, a less than 10% and probably less than 5% chance that any clear conclusion will be achieved if bullying is investigated, which is why it's far more appropriate to use things like mediation and conflict coaching when it's a bullying allegation. But on the rare occasion that it's a harassment allegation, that's very different. But when it's bullying allegation, it won't go anywhere. And so it's much more appropriate to try mediation, or if one or both people involved don't want mediation, to provide the option of conflict coaching for them. But if they don't accept any of those things, it's basically up to them to sort their own relationship out, because there won't be any basis for taking action against people on the basis of allegations of bullying, because there will never be a basis. Well, not never. Some people claim there is a basis for saying that you can prove that it's happened, but I mean, show me an example. I would be interested to see one which isn't subject to continuous appeals against it, where a bullying allegation has actually come to a clear and useful conclusion. So a good policy will clearly define harassment. It will set it apart from bullying, and it will clarify that a bullying allegation cannot go to an employment tribunal. Now, when that sort of thing's said in the policy right from the start, people know where they stand, People know what decisions they can make. People understand the possible journey that they're going to go on. But so many policies just don't give any of this. It really surprises me. It really surprises me how nebulous and ambiguous most bullying and harassment policies are. So, number four, the policy does not mention availability of relationship restoration support processes such as mediation and conflict coaching. So, the policies, uh, again, and number five will also feed into this. They kind of only talk about the adversarial possibilities of an outcome of a bullying allegation. So again, setting aside harassment, which, as I say, it would be so much easier if it was in its separate policy, but if it is within the two, keeping the caveat that if it's harassment and it can be proven to be harassment, which is obviously crucial, but if it's harassment, that won't be dealt with via mediation or conflict coaching. But if it's bullying, it's very unlikely to lead to any kind of conclusive outcome because it will be more about a difficult and broken relationship. However badly people may feel the other person has treated them, there won't be any legal outcome to it. It won't go to an employment tribunal. They will have a long, arduous, inconclusive investigation if they are alleging bullying and there's not an element of harassment within it. So it's in people's interest to consider the possibilities of mediation or conflict coaching. Now, they are voluntary processes, so people shouldn't be compelled to do it. That would be inappropriate as well, because that's like, well, I'm not sure you'd ever be able to compel people anyway. Some organisations might try it, but it would be inappropriate and it wouldn't be a very wise idea. But but if people want to compare the options available to them, which are a long and arduous and probably inconclusive investigation into bullying, and almost certainly they or the other person or both ending up leaving their job after lots and lots and lots of stress, then in the meantime, if there were availability of relationship restoration support processes, i.e., about trying to help people to reconcile their differences, at least come back to an effective working relationship, and using processes like mediation or conflict coaching to help them with that. There are various benefits of that for everybody. One is that it prevents the need for this long and inconclusive and ultimately almost purposeless investigation. It saves a lot of stress and a lot of time. It enables the possibility of people keep staying in their jobs and restoring and improving their working relationship. For the organisation, it means that they don't have to start the idea of recruiting for new team members because one or both are going to leave, whether it's the manager or the employee. It also means that the organisation is, unlike if it helps to resolve the situation, it means that an employment tribunal, which is ridiculously expensive, is going to be averted. But I mean, I could list forever the benefits because obviously I work in the field, but the point is that so many bullying and harassment policies make no mention whatsoever of mediation or conflict coaching. Again, bewildering that they make no mention of the availability of mediation or conflict coaching to the people involved. Now, again, I kind of always try to understand why, and I presume it's things like they want to be seen to be robust and, assertive and strong in their zero tolerance policies of bullying. But ultimately, it all becomes hot air in the end anyway, because people see that actually they can't be that robust and assertive on bullying, because it won't ever come to a clear conclusion. And one would imagine that after enough of these processes going through and them seeing that that's the outcome, they would want to review their policies and say, well, actually, we will be, assertive and supportive of our staff, but where it isn't clear that any conclusive outcome is likely, we will always make available to them the options of mediation or conflict coaching, or both even, although you'd rarely need both, but mediation or conflict coaching. But again, so many policies don't include that in what they say, and so they only seem to point to an assumption that the relationship is going to break apart, and that the only focus will be finding a victim and a perpetrator. And almost always that isn't going to happen with allegations of bullying. It will with harassment, if so long as there's evidence, but with bullying, almost certainly no clear outcome that one person is the victim and one is the perpetrator. More likely that both will claim to have been bullied, or both will claim misconduct on the part of the other person, and it won't be possible to come to a clear conclusion. So it's in the interests of the people involved to consider it at least. And as somebody pointed out the other day, the whole, or one of the main benefits of using mediation and conflict coaching is it places how things go forward back in the hands of the people directly affected. Because when investigations go on, people are just suspended or left in the dark or are passive throughout the process. Whereas with mediation and conflict coaching, it brings them back into it and gives them an element of influence over how their future at the organisation and their future working relationship with the other person is going to progress. So they're back in control of a large proportion of what might be happening. Whereas through the other processes, they have no control whatsoever. It's always at the whim of other people making decisions on their behalf. So there are so many benefits for people in allegations of bullying to have available processes such as mediation and conflict coaching. So with number 5, the policy is written in such a way that it assumes the workplace relationship will be irreparably broken. So what I would ask for anybody reviewing their policy is, does it look that way to you? When you're looking at your bullying and harassment policy, if you're someone who might have an influence over how it's written, what it contains, does it intrinsically represent an expectation that the workplace relationship will be broken, and so the only provision being made is for that to be the outcome, rather than any possible consideration of it being repaired, restored, etc. Again, with the caveat that if it's harassment or it's violence or it's gross misconduct of another form, that's very different. But where it's allegations of bullying, does it have any implication within it that actually there's a possibility for it to be restored, the relationship to be restored, or does it intrinsically suggest that once the allegation's made, the workplace relationship will be broken and forever broken and never get a chance to come back together again? Because if that's the case, you're writing your organisation is writing its own costs and talent loss into the process. It's not giving itself any opportunity to save all the money and time and stress devoted to dealing with such situations. It's not giving itself the opportunity to try to learn from and develop and change and become more resilient and become more supportive of its staff in resolving relationship breakdowns, and at the same time saving itself so much money and difficulty, not just on a financial basis but on a stress and morale basis for your staff, if your policy doesn't suggest any opportunity for the working relationship to be restored. And there's no reason whatsoever why that opportunity shouldn't be in there. It doesn't mean to say they all will be, but if it's not even acknowledged as a possibility within the bullying and harassment policy, how much of a waste is that? So number 6 is kind of a follow-on from the last two. So the policy does not mention an invitation to participate in mediation or conflict coaching in recognition that a legal outcome to a bullying investigation will not be possible. Now, the reason why I kind of see that as separate to the last two is because where there's a stated, clearly distinct statement that mediation, there's an invitation to participate in mediation or conflict coaching, then it's being very specific and clear, or explicit and clear, about that is a consideration and an availability and a resource available to people, so that it's not all about just going to an employment tribunal or not, and that's it, or there being a kind of an adversarial process or nothing. So when there's a specific invitation to participate in mediation or conflict coaching, then it means that people recognize that that is an option available to them, and they may or may not choose it. But the point is, if they don't even know through a specific reference to it that's available to them, they won't ever choose it anyway. And it is why for a lot of workplaces, mediation is just kind of an afterthought. It's not written into their policies, and so therefore it's used incredibly ineffectively and infrequently. And yet on so many occasions, again, what's to be lost by saying it? If people were to choose to use mediation, then first of all, or conflict coaching, their very choice indicates that actually it doesn't need to draw upon all those other investigations and reports and evidence gathering that's required. If people choose to do it, it's going to save all of that, unless it doesn't work, in which case obviously it will have to continue, but it would have had to continue anyway. But if they were to resolve it through mediation, or one person were to take up conflict coaching and their changes in the way they do things leads to a resolution of the situation, which is entirely possible. It may not need mediation, it may just need one person to look at how they're dealing with things such that they can improve how they relate to the other person, and it improves the situation. But if it's not even invited, if it's not even specifically referred to in the policy, how will that ever happen? So again, when that's not made available, or even if it is available, it's not referred to in the policy, the organisation is writing itself its own, or not exactly blank check, but enormous check. It's giving a kind of an enormous check for the costs that are going to follow, because the only option available, people, is to take that incredibly long and arduous and stressful and expensive route towards any kind of outcome to the situation. And simply because there's nothing referring to the option for people to try to resolve it themselves. And in many workplace disputes, people are willing to try that. But if it's not made available to them, how can they? So there we have it, why most workplace bullying and harassment policies are ineffective and what would make them more effective. So I've identified the 6 main flaws that I see in bullying and harassment policies, and why that means they often just drag on and on and on to no real conclusive end if it is about bullying. And as I say, if it's about harassment, then that's very different. And ideally they should be 2 separate policies so that the distinction is clear. But various ways in which any such policy, whether they're combined or whether they're separate, could be improved and clearer and more workable and more practical and more realistic in the eyes of the people both implementing them and the people who are drawing upon them because of difficulties they're experiencing. So as always, I hope you found it interesting, hope you found it useful. Quite a long video, but quite a lot to discuss about the many flaws that exist in most bullying and harassment policies, some worse than others, as I showed by that one example that I drew upon. If you've got any questions, please make contact with me. If you'd like support in your own organisation in developing a more effective bullying and harassment policy, please let me know, get in touch. If you like the video, please press the thumbs up button. If you dislike it, do the opposite, press the thumbs down. If you'd like to see more related to bullying, or generally about communication and conflict related issues, then please subscribe, and I'll see you in the next video. Thanks very much for watching. Bye bye.